If you're a green card holder, 2026 is about to feel very different. Imagine building a business for years, finally reaching the point where you're ready to expand, only to find out you no longer qualify for the very loan program that helped thousands of entrepreneurs grow. Imagine traveling overseas to see family and suddenly being pulled aside for extra questioning when you return. Not because you did anything wrong, but because scrutiny is tightening. And imagine applying for US citizenship after living here for over a decade only to have immigration officers reopen your original green card case from years ago. These aren't hypotheticals. These are policy shifts either already starting or rolling out in the coming months, and one of them comes with a deadline you absolutely cannot ignore. If you're a lawful permanent resident or about to become one, you need to understand exactly what is changing, why it matters, and what you can do right now to protect yourself. Hi, I'm Sofia, and this is Borderless Pathways. I work closely with immigrants every single week, and I can tell you this, the level of anxiety among green card holders right now is real. I speak to people who have lived in the United States for years, who have built businesses, raised families, paid taxes, followed the rules, and yet they're suddenly unsure about what their status truly guarantees. Some are afraid to travel, others are afraid to apply for citizenship, because they're worried immigration might look back at something small from their past and turn it into a problem. And now, with new rules rolling out between late February and into 2026, those concerns are getting louder. In this video, I'm breaking down 5 major updates that specifically affect green card holders. What's changing, who it impacts most, and what steps you should be thinking about right now. And we're starting with the change that could hit business owners the hardest. Let's start with the change that has a very clear deadline and very real financial consequences. Beginning March 1st, 2026, the Small Business Administration will require that a business be 100% owned by U.S. citizens in order to qualify for SBA loans. That means if you are a green card holder and you own even a small percentage of a company, 10%, 5%, even 1%, that business may no longer qualify for SBA-backed financing. And that is a major shift. For years, lawful permanent residents have been eligible to access SBA programs just like U.S. citizens. During COVID, SBA loans became a lifeline. Outside of emergencies, they've been one of the most important tools for entrepreneurs who want lower interest rates, longer repayment terms, and government-backed stability while they grow. For many immigrants, getting a green card symbolized freedom. The freedom to leave employer sponsorship, to start a company, to build something of your own without worrying about visa limitations. Now imagine working toward that independence for years, finally launching your business and discovering that your immigration status, despite being permanent, puts you on the outside of one of the most valuable funding programs available. This isn't just about large corporations. It's about family-owned restaurants, tech startups, construction companies, logistics firms, consulting businesses, many of which were started by immigrants who became green card holders after years of navigating the system. If your business structure includes a green card holder as an owner, this rule could disqualify the entire company from SBA financing. That means fewer options, potentially higher interest loans from private lenders, and in some cases, stalled growth. And here's the critical part. March 1st, 2026 is the line. If you are considering expanding your business and think you may need SBA support, the planning cannot wait until next year. You need to be evaluating your ownership structure, your financing timeline, and your eligibility now. Because once that date passes, the flexibility many green card holders relied on may no longer exist. This is one of those moments where being informed early makes all the difference. Immigration policy doesn't always change loudly. It shifts quietly, and then people discover the impact when it's too late. If you value staying ahead of updates like this, updates that directly affect your rights, your opportunities, and your future, make sure you're following Borderless Pathways so you don't miss what's coming next. Here at Borderless Pathways, I focus on breaking these changes down clearly, without panic, but without sugarcoating reality either, because the goal is simple. Clarity gives you power. Now, business restrictions are one thing, but what's happening at airports is creating a different kind of stress altogether. Over the past few weeks, we've seen a noticeable increase in secondary inspections for green card holders returning to the United States, particularly those traveling to certain paused or restricted countries. Let me be clear, this is not a wave of deportations. Lawful permanent residents are not suddenly being denied entry en masse, but more and more green card holders are being pulled aside for additional questioning after landing. And while most are eventually admitted without issue, the process is causing missed connections, rebooked flights, financial losses, and most significantly, anxiety. Imagine landing after a long international flight, expecting to go home, and instead being directed to a separate room for questioning. You're asked about where you went, why you traveled, how long you stayed, what ties you maintain in the United States. Again, in most cases, people are released, but the message many are receiving is clear. Scrutiny is increasing, and when scrutiny increases, preparation matters. If you are a green card holder planning international travel, especially to countries currently under heightened review, build in extra time between connections. Carry documentation that reinforces that the United States remains the center of your life. That can mean proof of employment, mortgage or lease documents, tax filings, evidence that your immediate family resides here. You may never need to show it, but if you do, having it ready can shorten the process significantly. There's also growing concern about electronic device searches. Green card holders do have more constitutional protections than temporary visa holders, but that doesn't mean requests to inspect phones or social media accounts aren't happening. Refusing to unlock a device can lead to extended delays. Complying can feel uncomfortable. This is the reality many lawful permanent residents are navigating right now. A balancing act between knowing your rights and wanting to avoid hours of detention at the airport. The vast majority of green card holders continue to travel without incident. That's important to emphasize. But the pattern of increased questioning is real enough that ignoring it would be irresponsible. And here's the deeper issue beneath both of these changes: the sense that permanent residency does not feel as permanent as it once did. Whether it's financing restrictions or airport scrutiny, green card holders are starting to feel like they're under a microscope in ways that weren't as visible before. The question becomes, if this is happening at the business level and at the border, what else is shifting beneath the surface? Because the next update isn't about people who already have green cards. It's about those trying to get one, and the ripple effects may extend further than you think. The next shift is centered around something that has shaped immigration policy for years, but is now resurfacing in a stricter form: public charge enforcement. If you already have your green card, this does not mean you suddenly lose eligibility for benefits you're legally allowed to receive. Lawful permanent residents, in many situations, qualify for certain public programs. That hasn't changed. But what is changing again is how the government evaluates people who are applying for a green card now, and how past benefit usage may be reviewed more aggressively during the application process. An expanded public charge framework is expected to roll out in a more structured and possibly more restrictive way, introducing a clearer risk assessment model. In practical terms, that means officers may look at factors like income, employment history, education level, age, health, family size, and past use of certain public benefits to determine whether someone is likely to become dependent on government assistance in the future. Even if the majority of applicants are ultimately approved, the standard of scrutiny may rise. And when scrutiny rises, documentation becomes everything. Why does this matter to current green card holders? Because immigration processes are connected. Let's say someone applied for their green card during a period when public charge rules were interpreted more loosely. Years later, when that same person applies for U.S. citizenship, officers may review the entire immigration history again. They may revisit financial sponsorship documents. They may look at affidavit of support. They may examine whether any inconsistencies existed in prior filings. For most people, there will be no issue. But for some, especially those who relied on benefits during complicated life transitions, job loss, medical emergencies, family hardship, the fear is not necessarily about wrongdoing. It's about interpretation, and interpretation can shift depending on the political climate. There is also a broader policy narrative at play. Concerns about public benefits usage have been cited as justification for travel pauses affecting certain countries. The underlying argument from policymakers is that immigration should prioritize self-sufficiency. Whether you agree or disagree with that philosophy, the practical takeaway is this. If you are currently in the green card application process or planning to start it soon, be extremely mindful about the benefits you apply for and receive. Before making decisions that could later be questioned, speak with an immigration professional who can assess your specific situation, because once something appears in your immigration file, it becomes part of the permanent record that can resurface years later, and that leads directly into the next development, which for many people is the most unsettling of all: the government's ability to revisit and potentially resend previously approved green cards. In late 2025, policy guidance made it clear that immigration authorities could review green card approvals from several years back, sometimes 4 or 5 years, and in certain cases even further if discrepancies or potential misrepresentations are discovered. Now, we're beginning to see this authority being exercised more visibly. One of the most common triggers, a citizenship application. Imagine living in the United States as a permanent resident for over a decade. You've built your life here. You finally decide to apply for naturalization. During your citizenship interview, instead of focusing solely on your eligibility for citizenship, the officer begins asking detailed questions about how you obtained your green card 12 or 14 years ago. Maybe it was marriage-based. Maybe it involved employment sponsorship. Maybe documentation standards were different at the time. Suddenly, small inconsistencies, things you barely remember, are being examined with fresh scrutiny. In some instances, individuals have received a notice of intent to resend their green card because the government believes there were discrepancies in the original approval. It's important to keep perspective. This is not happening to the majority of green card holders. It is not a widespread cancellation campaign, but the existence of this review power and the fact that it's being used changes how people feel about filing for citizenship. It introduces hesitation. It raises questions like, should I dig out my entire old file before I apply? The answer increasingly is yes. If you are preparing to submit an N-400 for naturalization, review your original green card case carefully. Make sure the information you provide now is consistent with what was submitted then. If you were represented by an attorney years ago, obtain a copy of your file. If you filed on your own, request your immigration records if necessary. The goal isn't to create fear, it's to remove surprises. Because here's the pattern emerging across all of these updates. Scrutiny is increasing in multiple areas at once: financial eligibility, travel, public benefits, and historical case review. None of these changes on their own eliminate the value of a green card. Lawful permanent residency still provides enormous stability and opportunity, but it is no longer something you can afford to treat passively. The environment is shifting toward closer examination, and preparation is becoming the difference between a smooth process and a stressful one. And there is still one more shift happening, one that affects not just individual green card holders, but the overall direction of immigration priorities moving into 2026. The final shift isn't a single rule change. It's a broader prioritization trend that's becoming harder to ignore. We're seeing stronger momentum behind wealth-based and investment-driven immigration categories. While many family-based categories continue to move at a painfully slow pace, programs designed for investors, entrepreneurs with substantial capital, and high-skilled individuals are being positioned as economic drivers. At the same time, family preference categories like F2B, F3, and F4 remain stuck in long backlogs, with processing times stretching years beyond what most families expected when they first filed. There's ongoing legal debate around newer investor-focused pathways, and lawsuits have been filed challenging aspects of these programs. Critics argue that prioritizing capital over long-awaiting family members undermines fairness in the system. Supporters argue that economic investment strengthens the country. Regardless of where someone stands politically, the practical impact is clear. Resources and processing attention often follow policy priorities. When a category is emphasized, it moves faster. When it's not, it stalls. For families who filed petitions years ago, siblings of U.S. citizens, adult children of permanent residents, married sons and daughters of citizens, the message right now is not to wait passively. If your priority date is current or approaching, stay aggressive about document submission. Move quickly through the National Visa Center process. Respond to requests immediately. Keep your contact information updated. And if your case has been sitting unreasonably long without movement, understand that legal tools like mandamus lawsuits exist to push agencies to act. Many people hesitate because they feel suing the government sounds extreme. But when cases are outside normal processing times and families have waited beyond reason, legal action is sometimes the only mechanism that forces resolution. What does this mean for current green card holders? It reinforces a larger theme. Immigration benefits are becoming more conditional on strategy, timing, and awareness. The era of file it and forget it is fading. Whether you are expanding a business, traveling abroad, applying for naturalization, sponsoring a family member, or adjusting status, each step now requires more intentional preparation than before. So, let's zoom out and look at the full picture of what's changing as we move into 2026. First, SBA loans may become unavailable to businesses that include green card holders in their ownership structure after March 1st, 2026. Second, international travel is seeing increased secondary inspections and device scrutiny for some returning permanent residents. Third, expanded public charge enforcement may complicate new green card applications and echo into future reviews. Fourth, previously approved green cards can be revisited during naturalization or other proceedings if inconsistencies are discovered. And fifth, immigration priorities appear to be leaning more heavily toward wealth-based categories, while many family-based cases remain delayed. None of this means green card holders are losing their status overnight. It does not mean panic. It does not mean permanent residency has no value. A green card still provides the right to live and work in the United States indefinitely. It remains a powerful and meaningful status, but it does mean that complacency is no longer safe. You need awareness, you need documentation, you need planning. If you're a business owner, review your financing timeline now. If you plan to travel, prepare thoroughly and leave room for unexpected delays. If you're applying for citizenship, examine your original immigration file before submitting anything new. If you're in the process of getting a green card, think carefully about financial documentation and benefit usage. And if you're waiting in a family-based category, stay proactive and informed about your options. The anxiety many green card holders are feeling right now isn't irrational. It's coming from real policy movement and real experiences shared by people just like you. But fear alone doesn't protect your status. Information and preparation do. The immigration landscape is shifting, and the people who navigate it successfully in 2026 will be the ones who stay informed and act early instead of reacting late. As these policies continue to evolve, I'll keep breaking them down clearly and honestly here on Borderless Pathways, so you know exactly where you stand and what steps make sense for your situation. Because at the end of the day, your life, your business, your family, and your future here deserve careful protection, not guesswork.